Good morning to those who have joined. We're just going to give it one more minute to let a few more people to join before we kick off. Good morning, everyone. I see we're over 40 participants, so I think we'll kick off. Hello to everyone on what I think is a very chilly day across the country. Welcome to our second employment law update for 2024. We are not short of, as usual, some very interesting cases which impact on the employment law landscape in South Africa, including a handful of constitutional law cases. My name's Helen Wilsoner, and I'll be facilitating this morning's update. I'm joined by my colleagues in our employment and benefits practice, which I'll introduce as we get to each of the cases. However, if you're a regular attendee, I'm sure everyone on the call is very familiar to you. We seem to have a very female-heavy lineup today, but Komotso will also be joining us a bit later. Before I begin, I'd just like to run through a few housekeeping matters, which will hopefully enhance the webinar experience for everyone. As participants, you're all automatically muted, and the chat functionality has been disabled. So if you have any questions, if you could just pop them in the Q&A tab at the bottom of your screen, they'll then be submitted to me, and we will try and get to all of those as we go along. Unfortunately, we won't be providing any written responses to questions, but the webinar is being recorded, and a copy of it will be available on our website at www.bowmanslaw.com. In addition, we'll also be, as we normally do, sending you a high-level summary of all of the cases that we discussed this morning, with the key takeaway legal principles highlighted for you. And these summaries will come through during the course of next week. So without further delay, let's begin. Our first two cases are retrenchment cases. Talita Lopesha, a partner in our practice area, will be kicking off with the first one, which very interestingly looks at the test for merger-specific conditions as to what is a permitted retrenchment. And straight after, Talita Nadine will be taking us through a second case, an LAC case, also dealing with retrenchments and whether they were substantively fair. Over to you, Talita.
Good morning, everyone. Yes, this constitutional court case of Coca-Cola Beverages Africa, CCBA, and the Competition Commission and FAWU, the Food and Allied Workers Union, had its origin in the large merger that took place in 2016. You may be aware that before that large merger, there were 4 bottlers in South Africa, ABI, Amalgamated Beverages Industries, that was formerly part of the then SAB, Shanduka Canners, and Sapco. And each of these bottlers had the right to bottle and distribute the products from the Coke system. So in terms of that system, it was quite interesting. The country was divided in various areas, and each of these entities were only allowed to distribute and sell Coke products in their specified area. This wasn't very efficient, and these 4 bottlers came together, and they all formed CCBA. Coca-Cola Beverages Africa Limited, now a big organization. In terms of the Competition Act, where there are mergers or acquisitions and certain thresholds are met, the merging parties are required to get Competition Commission approval, and that is governed by the Competition Act. As part of making this assessment as to whether a merger is permitted or must be prohibited, the impact on employment is considered as part of the assessment of the public interest that might be affected by this merger. So is it going to enhance competition? Is it going to reduce competition? And importantly, what is going to happen to the employees? And what we have seen over the years is that the Competition Commission looks very critically at what is going to happen with employees as part of that public interest inquiry. And in this case, it was actually agreed between the parties that certain employment conditions would apply. Now, these included that there wouldn't be any retrenchments as a result of the merger in the bargaining unit, and that the retrenchments in relation to the more senior levels of employees, higher grade 12 and above, would be limited to 250. And it was easy for the parties to agree this because they still required the lower level employees to distribute and manufacture these products. The actual duplication of functions would happen at managerial level and above. So that was agreed, and that became part of the condition for allowing this merger. The other condition was that after the merger, there would be the four entities would continue to have the same number of employees as existed before the merger. And that condition on the maintenance of numbers of employees existed for 3 years after the merger. Shortly after this merger, there was also a big transaction where SAB then sold off its interest in the Coke entity, and it became part of AB InBev. And then that 3-year period in relation to the maintenance of numbers actually took effect from the AB InBev transaction. So things happen in business. And with effect from the 1st of April 2018, the health promotion levy on sugary beverages came into force. That is commonly referred to as the sugar tax. So all of a sudden, to make Coke and other products in the Coca-Cola stable became much more expensive. Prior to that levy being implemented, CCBA, as well as FAWU, made representations in relation to the imposition of this duty, this tax on sugary beverages. But nevertheless, it was imposed, but all along, FAWU was very aware that this might have adverse effects on the profitability of CCBA going forward. So, as I mentioned, this merger took place in 2016. The sugar tax was imposed in 2018. And then on the 19th of January 2019, Coca-Cola wrote to the Commission and said, there are now retrenchments that are contemplated. They are not related to the merger that took place in 2016. It is because of these huge economic factors, the need, an urgent need to reduce labor costs. And they explained that they actually already lost about 2.1 billion since the introduction of the sugar tax. They emphasized that this is not as a result of the merger, but was as a result of these external economic factors that now played in on the company's operations. The commission wrote back and asked, what about the obligation to retain the number of employees after the merger as set out in the merger conditions? And the company said, we are there. We are actually going to be able to maintain numbers, but there are actually now going to be retrenchments in the bargaining unit, but these are not related to mergers or to the merger that took place earlier. In terms of the Competition Act, the Competition Commission issued a notice of apparent breach of the merger conditions. And when such a notice is issued, the party against which it is done has two potential options. It can submit a remedial plan to the Competition Commission, in which it then acknowledges that it is in breach of the merger conditions. And these are then the steps that will be applied in order to address the breach. Or it can review that notice of apparent breach. And in order to do that, it needs to go to the Competition Commission Tribunal. The company engaged with the commission, it explained again, and then ultimately it then took the second option. It referred the matter to the tribunal, and it said, listen, we are not in breach. These are not merger-related retrenchments, and we must be allowed to go forward. The labor issue is dealt with separately, but from a competition law perspective, this is not a breach of our conditions. The consequence of a breach of merger conditions are substantial. The whole merger can be set aside. There can be administrative penalties related to turnover. So it is really serious when you are not complying with your merger conditions. The commission opposed this review in the tribunal, but the tribunal looked at it carefully and then assessed that actually there wasn't a breach of the conditions. The condition to maintain numbers was complied with, and the condition not to retrench in the bargaining unit or more than a certain number in high grade 12 and above, that was not merger related. So it then reviewed that decision. The commission was unhappy with that decision and took it to the Competition Appeal Tribunal. And I will not bore you with the difficult legal questions, but the appeal court, apologies, is the Competition Appeal Court then grappled with. But it said actually this review is a review in the narrow sense. And what the company tried to do in the tribunal was to appeal the decision of the commission. And the tribunal looked into the merits of whether or not this was in fact a merger-related retrenchment or not. While, in fact, if it was a true review, it had to look into whether or not there was some procedural irregularity or misconduct in the process. So the Competition Appeal Court then set aside the decision of the tribunal, and that now meant that the company was in apparent breach. That decision was taken on appeal then to the Constitutional Court. So in the Constitutional Court, the court looked carefully at the test that must be applied in these circumstances. So it said that actually the tribunal was completely correct. There is only a breach, and the consequences of a breach of a merger condition if there is an actual breach, not an apparent breach. So this section 39 of the Competition Act is designed to make that specific inquiry as to whether there is an actual breach or not. So it was completely correct for the tribunal to look into the specific facts, into the question whether these retrenchments were merger related or not. It wasn't necessary to go into procedural unfairness or some problem in the process as would exist in the case of a typical review. The tribunal understood its function and the tribunal exercised its powers correctly, and it held that there wasn't that causal nexus between the merger and the retrenchments that now took place because of the imposition of the sugar tax and the huge economic impact that had on CCBA. So the Constitutional Court set aside the Competition Appeal Court's decision, and Coca-Cola was able to prove that it was permitted in those particular circumstances to embark on a retrenchment process.
Thanks, Talita. Over to you, Nadine.
Morning, everyone. Thanks very much, Talita. I am doing also a judgment that concerns Coca-Cola Beverages South Africa. And this case had its origin in the same retrenchment process conducted in the case discussed by Talita. After Coca-Cola Beverages South Africa, referred to as CCBSA, retrenched employees due to its operational requirements, the National Union of Food, Beverages, Wine, Spirits and Allied Workers referred a dispute to the Labour Court in respect of the substantive fairness of the dismissals, in which it sought for the employees to be reinstated or alternatively to be awarded compensation. Now, these proceedings interestingly ran parallel to the proceedings in respect of the Competition Act, specifically that CCBSA had breached the merger conditions, and the union in the specific matter relied heavily on the Competition Appeal Court's judgment in support of their argument that the retrenchments were substantively unfair. However, shortly before the hearing of this appeal before the Labour Appeal Court, the Constitutional Court judgment was delivered, which, as Talita has explained, in short found that there was insufficient evidence to establish that the merger was the principal reason for the retrenchments. And it's really against this background that the Labour Appeal Court determined the matter. So briefly, from a factual perspective, the background is as follows. The Coca-Cola company manufactures concentrate for the production of non-alcoholic beverages, and it supplies these concentrates to bottlers to manufacture and distribute its branded beverages. And CCBSA is one such bottler. Now, as mentioned by Talita, during 2017, the economic conditions deteriorated, and the year after, the sugar tax was introduced. Now, as a result, CCBSA, I think, paid around 2 billion rand in sugar tax for that year. It was forced to give discounts to remain competitive within the market, and its sales volumes declined drastically. In order to try and ensure the short and long-term viability of the business, CCBSA then initiated various strategies with the competition conditions in mind. They sought to streamline roles, they placed a moratorium on new appointments, and they tried to use early retirements, resignations, and voluntary severance packages to reduce the impact of the challenging operating environment. This was just simply not enough. So CCPSA then initiated a Section 189 capital A process, which was facilitated by the CCMA and issued a 1893 notice to the relevant unions. They, of course, explained the economic headwinds, the introduction of the sugar tax, and the fact that it urgently needed to restructure its operations to become more efficient and cost-effective, and in essence, viable going forward. Now, the dispute before the court in this matter specifically concerned two roles, that of a merchandiser and that of a pre-seller. Now, merchandisers were engaged in large retail outlets, and they were responsible for, in essence, packing fridges and shelves, whereas pre-sellers were engaged in smaller outlets, such as spaza shops or house shops, and they sort of managed those operations. Now, the 1893 notice proposed, firstly, a reduction in the roles of the pre-sellers that were available, and proposed to actually abolish the role of merchandiser as it currently was, with a new role with the same title, but just a change in terms and conditions, and in fact less favorable terms and conditions being created, which would be offered to the merchandisers. Now, at the conclusion of the retrenchment process, I think around 368 employees had been retrenched who fell within the bargaining unit. And in the present matter, the union brought the dispute in respect of 21 employees who were either previously employed as a merchandiser or a pre-seller. Okay, so against this background, when it got to the Labour Court, the union brought a challenge on the substantive fairness of the dismissal on a number of grounds, I think around 13 grounds. But the most notable grounds for purposes of the judgment was that first, the retrenchments were substantively unfair because they constituted a breach of the conditions. Second, that the dismissals in respect of at least the merchandisers could be regarded as automatically unfair in terms of Section 1871C of the Labour Relations Act, on the basis that it was in effect a refusal to an accepted demand. And thirdly, that the employer had unfairly implemented selection criteria in respect of the pre-sellers who were to be retrenched. Now, CCPSA in the proceedings led extensive evidence. Their evidence covered the fact of the commercial rationale, the reduced volumes, the sugar tax, the fact that their profitability had decreased, and this evidence remained unchallenged. Now, in respect of merchandisers, it led evidence to say that the role of a merchandiser was in effect a legacy role, which had been absorbed by CCPSA after the merger. They didn't have merchandiser roles. They had, in fact, outsourced this function to a third party, but they had absorbed these roles following the merger, and they had to restructure these roles to align them with the sort of value for work and the terms offered to the third party supplier that had been outsourced to perform this function. In respect of the pre-sellers, evidence was led to say that the investment in a customer base that was responsible for such a small revenue had to be relooked, and CCPSA needed to invest in bigger revenue outlets. This was the reason for the reduced positions of pre-sellers. And as regards the selection criteria, CCPSA said that the selection criteria that was applied was LIFO, subject to the retention of skills, and this was agreed between the parties during the consultation process and applied fairly. The Labour Court the union led some evidence, but not a lot of evidence, specifically in respect of the 21 employees concerned. There was 2 employees who gave evidence. One was a pre-seller who testified that he did not know why and how he had been selected for retrenchment, and the other was a merchandiser that testified that the new role offered and the lower salary was something that he could not accept. The Labour Court, in short, rejected the union's submission that the retrenchments were related to the merger, and said that the issue, at least for purposes of the LRA, is to establish whether the dismissals were substantively unfair. Now, again, it also rejected the submission that the dismissals were automatically unfair based on a refusal to accept a demand, as it noted that a refusal to accept a demand is not akin to an offer of alternative employment in the operation of a retrenchment process. There was also no evidence led to show that there was a refusal on part of the employees. The court noted that there was overwhelming evidence of a valid commercial rationale in order to restructure its operations, and that it applied selection criteria on the basis of what had been agreed between the parties. Noting this, however, there was one employee, Mr. Mbata, who was a pre-seller, who gave evidence to say he was selected for retrenchment, but he was not offered alternative roles, or at least properly considered for alternative positions. And in respect of this one employee, the Labour Court did find that he was not afforded with an opportunity to respond to the assessment of his skills and qualifications for an alternative position, and for this reason concluded that the selection criteria was not fairly applied to Mr. Mbata and awarded him compensation equivalent to 4 months. But save for Mr. Mbata and his 4 months compensation, the Labour Court dismissed the remainder of the union's claim. Obviously disgruntled by this, the union took the judgment on appeal to the Labour Appeal Court, and it was on similar grounds. I won't list them all again, but I will deal with each ground as it was determined by the Labour Appeal Court in turn. As regards the breach of the merger conditions, and don't want to hammer this home further than Talita has already discussed, but in essence, the court noted that the judgments by the Competition Appeal Court and the Constitutional Court were concerned with the ruling made by the Competition Tribunal in respect of the notice of apparent breach. The issue of the fairness of the retrenchments did not come before the competition authorities, let alone come before the Constitutional Court. So this was in fact conceded by the union before the Labour Appeal Court, that the judgment, or at least the constitutional judgment, was not helpful to the court, and it was not necessary for the court to consider that judgment in determining whether the dismissals were substantively fair or not. So that was the end of that matter. In respect of the allegation of automatically unfair dismissals, which was only applicable to the merchandisers and not the pre-sellers, the union contended that the retrenchment was designed to compel the employees to accept new and less favorable conditions, and thus it was the reason for their dismissal to refuse to accept these terms. Now, the Labour Appeal Court noted that, of course, Section 1871C provides that a dismissal is automatically unfair if the reason for the dismissal is a refusal by employees to accept a demand in respect of a matter of mutual interest. Now, the court said specifically here, there has to be a factual and legal causation of the dismissal that must be determined. And this has been endorsed by the Constitutional Court previously. And the questions that must be asked is, first, whether the dismissal would have occurred had the employer refused the demand. So this is the so-called but-for test. And second, whether the dismissal or whether at least the refusal was the main, dominant or proximate cause for the dismissal. Now, in this matter, the only witness to testify about the retrenchment process offered no evidence that there was a demand made by CCBSA or that there was a refusal. His evidence was simply that after he was informed that he was selected to be retrenched, he was offered alternative positions and he refused the offers of alternative positions on account of the drop in remuneration that he would suffer. So nowhere in his evidence did he make reference to a demand. Nowhere in his evidence did he make reference to a refusal in respect of a demand. His evidence was that offers were made, which he refused, and they were exactly that, offers of alternative employment. So on this basis, the court found that there was no demand, let alone a refusal. And even if one applies the but-for test, it was noted that the merchandisers would not have been dismissed had they accepted the new post. So the test in that regard didn't apply. The court, in conclusion, held that you cannot state in respect of 1871C that an offer of alternative employment under the umbrella of a retrenchment or consultation process can constitute a demand for which can be refused by employees. There is an obligation on an employer under 189 to consider alternatives short of dismissal, and this was exactly that. So the court found that there was no evidence in this regard and dismissed the union's claim that the dismissals were automatically unfair. Turning to the substantive fairness of the dismissals and the selection criteria, which was sort of the last aspect that the Labour Appeal Court had to consider. The court just noted that, when considering substantive fairness, there does have to be an objective link between the dismissals and an operational requirement. And whilst employers have the prerogative to determine how to restructure its operations for efficiency or profitability reasons, the court doesn't have to accept this on face value. The court's function is simply to determine whether there was a rational decision, properly, of course, taking into account the consultation process. The union's submission that there was no need to retrench employees just simply couldn't be sustained. There was overwhelming evidence of a commercial rationale led by CCBSA, and the court on this basis just simply held that on the basis that this evidence wasn't challenged, there was an operational rationale, and there's no, as I said, no sort of substance to that claim. In respect of selection criteria, and save for our friend Mr. Mbata that I've discussed before the Labour Court, his finding and his sort of unfairness of his dismissal wasn't challenged before the Labour Appeal Court. So the decision from the Labour Court to say that his dismissal was unfair and his 4 months compensation stood, and it didn't come before the Labour Appeal Court. So in respect of the other employees, what the Labour Appeal Court found was that the selection criteria had been agreed between the parties and it had been applied. And to the extent that the employees were alleging that they'd been excluded from being considered for alternative positions, they had to lead evidence to show this exclusion. Now, save for Mr. Mbata, who led evidence, there was no evidence in respect of the remaining employees. And the court said you can't simply take the evidence of one employee and apply a blanket approach across all other 20 employees. You have to lead evidence to show why each employee was specifically excluded or the selection criteria was not properly applied. So on this basis, the court rejected the union submissions and in effect upheld the Labour Court's findings on all of the submissions made by the unions. So just in respect of key takeaways, I think CCBSA followed quite a good approach in respect of leading evidence. They led a lot of evidence. To note, in respect of a refusal to a demand, we get a lot of questions from clients about how to change terms and conditions and the risk here in respect of retrenchment processes. The court has noted that if you are going to do it under the umbrella of a retrenchment process and it is constitutes an alternative to a dismissal, an alternative offer of employment, this is not going to constitute a demand on which a refusal, can be found to be automatically unfair. So that is just one sort of key takeaway to note in respect of retrenchment processes. Thanks, Helen.
Thanks, Nadine. Melissa, partner in our Cape Town office, is going to take us through the third of our 10 cases today. And we're moving back to the Constitutional Court, but staying with retrenchments, in this case, the Labour Court's jurisdiction to hear procedural fairness challenges. Thanks, Melissa.
Thanks. Good morning, everyone. I'm going to be discussing Regenesis Management versus Lunga and others. It's a 2024 decision from the Constitutional Court that was handed down in May earlier this year. And in that case, during 2015, Regenesis Management had conducted a restructuring exercise that resulted in the dismissal of a number of employees for operational requirements. And this dismissal constituted a large-scale retrenchment process, and therefore the provisions of Section 189, capital A, applied to those dismissals. Then the employees that were retrenched referred to disputes. One of the disputes they referred was in terms of Section 191 of the LRA, and that's where the matter was conciliated at the CCMA for an alleged unfair dismissal based on operational requirements. They then also brought a claim in terms of Section 189, capital A, sub 13, which is a specific provision applicable to large-scale retrenchments, which I will touch on briefly, on the basis that it was also procedurally unfair. And that subsection 13 claim was brought on an urgent basis, where the employees sought to be temporarily reinstated or to receive compensation in the alternative. At a certain point in time, both of those two referrals were consolidated. And at the Labour Court, it was found that the employees' dismissals were both procedurally and substantively unfair. So the Labour Court did deal with the question of procedural fairness. Now, as I've mentioned earlier, there are specific provisions that deal with large-scale retrenchments. One of them, which has caused a lot of confusion, is 189 capital A sub 18, which provides that the Labour Court may not adjudicate a dispute about the procedural fairness of a dismissal if it's based on the operational requirements of an employer, and that dispute is referred in terms of section 191 5B. And I mentioned earlier that section 191 is one of the claims that the employees brought. The other provision that's applicable in relation to large-scale retrenchments, and specifically in relation to claims of procedural unfairness, is a claim that can be brought in terms of section 189 capital A sub 13, where employees can approach the Labour Court for an interdict, reinstatement, or compensation if they claim that the employer is not complying with a fair procedure. So this is a special mechanism that's available to employees when they're facing a large-scale retrenchment and they're alleging that the process is unfair. The matter then went on appeal to the Labour Appeal Court, and the Labour Appeal Court was only willing to confirm the substantive unfairness of the dismissals, and held that the Labour Court didn't have jurisdiction to determine the procedural fairness as a result of subsection 18 of section 189 capital A. And the Labour Appeal Court's view was that that section ousted the Labour Court's jurisdiction. So for purposes of my discussion of this case this morning, I'm only focusing on the aspects of the judgment that deal with procedural fairness, as this is the area where this case is most significant and where the Constitutional Court has clarified the position in law. So prior to this Constitutional Court decision, and what the Constitutional Court looked at was a lot of confusion as to the Labour Court's jurisdiction to entertain a claim of procedural fairness when dealing with a large-scale retrenchment. And there has been a view that because of subsection 18, the Labour Court's jurisdiction was ousted when the matter dealt with procedural fairness in large-scale retrenchments. And the court held here that the purpose of section 189A sub 13 is to provide special remedies to employees facing large-scale retrenchments, and those applications are ordinarily brought on an urgent basis, and it enables a court to intervene by setting a derailed retrenchment back on track. So in that case, the court can intervene and immediately reinstate employees back into the position, or can direct the employer to comply with procedural fairness until the end of the process. And there the court said that the primary purpose of that section was to compel compliance with fair procedure. And so its primary purpose is intervention in a process that is still ongoing, or it could also reverse a dismissal if it was appropriate to do so. The secondary purpose is also that if it's a particular situation where reinstatement or reemployment or interdicting the employer is no longer appropriate because perhaps there could have been a long period of time that's passed before it's eventually heard by the court, the Constitutional Court held that subsection 13 also provides for the remedy of compensation, which can be brought as a primary remedy, and it can be brought as a standalone remedy. So it doesn't have to be contingent on whether reinstatement or reemployment is appropriate in those circumstances. It can be claimed right at the outset. Then it dealt with subsection 18 and the question of whether this ousted the Labour Court's jurisdiction to deal with procedural fairness. And the Constitutional Court correctly held that that's not the case, that if a claim is brought in terms of subsection 13, the Labour Court still has the jurisdiction to determine the procedural fairness. It's only in relation to the other claims that are brought in terms of section 191, where the court would be limited to consider the substantive fairness of the dispute. So in that particular case, the Constitutional Court has clarified the process and has clarified that if there is large-scale retrenchments and if procedure is being challenged, that claim must be brought in terms of subsection 13 and not only in terms of section 191. And in this case, the employees had actually referred both a section 191 dispute and a subsection 13 dispute. It then also touched on whether this has an impact on ordinary retrenchments, and the court said that it doesn't. Subsection 18 in section 189 capital A is specific to large-scale retrenchment. So it doesn't impact at all any normal size retrenchments where an employee can refer a dispute in terms of section 191 and claim both procedural and substantive unfairness. Thanks, Helen.
Thanks, Melissa. We're going to pivot a bit in our next two cases. The next case deals with trade unions membership and their registered scope. And Amandla, Senior Associate in our Sandton office, is going to be taking us through that case. And straight after that, we're going to move to Soraya, Associate in our also in our Sandton practice area, and who did a lot of the heavy lifting in putting this this presentation and this ELU together today. So thanks, Soraya. And Soraya is going to be taking us through a case that speaks on a very hot topic for employers, and that is the validity of sick notes. Thanks, Amandla.
Thanks, Helen, and good morning, everyone. So this is a matter between Animal Feeds, which is a division of Phil Africa Foods. You might be familiar with it. It produces animal feed for your cattle, your rabbits, and it has even dog food production. So for all the animal lovers, that might be a familiar name. And all too familiar also to us is the National Union of Metal Workers South Africa, which is NUMSA. So what happened in this was NUMSA sought to get organizational rights within AFGRI, and that did not work out. So of AFGRI embarked on an unprotected strike because they wanted NUMSA to be part of the union within AFGRI. Now, unfortunately for them, they were dismissed and they went to the CCMA, conciliation failed, and they went to the Labour Court. NUMSA, acting on behalf of these employees, referred that dispute first at the CCMA and at the Labour Court. And in of claim, it is cited as the first applicant, with the employees being the rest of the applicants. Now, AFGRI raised a preliminary point objecting to NUMSA's legal standing on the basis that NUMSA's constitution limited ability for membership to the trade union itself, only to employees within the metal and related industries, and but had excluded or precluded the dismissed employees who were employed specifically in the animal feeds industry. The two distinct industries. AFGRI relied on Section 161 of the Labor Relations Act, which states that representation by a trade union in the labor court is only limited to, a representation by a trade union in the labor court is provided where the party from the office bearer or an official, and the trade union itself must be registered. Now, obviously, NUMSA is a registered, it has office bearers, it has officials, and so they thought there's no problem with them representing the dismissed employees at the labor court to the LRA. Now, considering the preliminary point, the labor court held that this inquiry is going to unfold in two ways. The first inquiry related to whether NUMSA had the right to refer the matter in its own and in the interest of the members. And the Labour Court held that in terms of Section 161 of the LRA, Section 200 of the LRA, a trade union may refer a dispute or represent a dismissed employee in the Labour Court only that trade union is registered and the employee who is a party to the dispute is a member of that trade union. The second inquiry, the Labour Court considered whether NUMSA had the right to represent the dismissed employees. Considered the principle laid out in another constitutional court decision that involved NUMSA that was handed down in 2020, where the Constitutional Court held that NUMSA, as a voluntary association, was bound by its own constitution, had no power to act beyond it. In this regard, the Labour Court concluded that since a trade union could only act members falling within the scope of its registered constitution, NUMSA's referral of the dispute was invalid and void, as NUMSA lacked the necessary legal standing to launch the proceedings on behalf of the dismissed employees. And you would remember that these employees, animal feeds industry, and that's what motivated the Labour Court's decision. Now, NUMSA, aggrieved by the Labour, approached the Labour Appeal Court. And one would think that now being made aware of the Court was involved in 2020, NUMSA would just let things be. But it persisted with its argument that it could act on behalf of these employees and it had the legal standing to do so. Now, on the first inquiry as considered by the Labour Court, the Labour Appeal Court found that both NUMSA, acting on behalf and in the interest of the members and the dismissed employees, were represented by their attorney, which is in line with Section 161 of the LRA. Therefore, the Labour Appeal Court found that the argument in respect of that particular provision was not applicable because legal representation is permitted in the Labour Court. In respect of the second inquiry, the Labour Appeal Court relied on its 2016 decision, which predates the Cone Court's decision. And this is a decision in McDonald's Transport Uppington, Pty Ltd versus AMCU. And what the Labour Appeal Court did was to draw a distinction between a trade union's exercise of organizational rights on behalf of its members on the one hand, and its representation of employees in an unfair dismissal dispute where the workers have a right to choose a particular trade union to represent them on the other side. And the Labour Court held that the Luffield judgment that the Labour Court had relied on was not concerned with the trade union's suitability to represent employees in an unfair dismissal or unfair labor practice dispute, but with the role of a trade union's constitution in giving effect to organizational rights. So what it did was to say, on the one hand, we've got organizational rights, and on the other hand, we have these employees that need representation, and they've chosen us as their union. So in that regard, the Labour Appeal Court said, okay, you're right. We are going to consider the fact that you're here to represent these employees who are alleging that that dismissal was unfair. And that is the sole purpose of your representation in the dispute. In this regard, the Labour Appeal Court found that NUMSA's approach promotes access to justice and redress to employees, which is in accordance with sections 23 and 38, of the Constitution and prevailing legislation. Now, AFGRI was not too happy about the Labour Appeal Court's decision in respect of NUMSA being able to act on behalf of its its employees. So they approached the Constitutional Court for its determination, which basically means that NUMSA again is appearing before the Constitutional Court on a similar set of issues where they are representing members outside of their constitution. Now, the Constitutional Court also considered what the Labour Court considered that twofold test. And in the first instance, it agreed that NUMSA and the dismissed employees, party to the proceedings, were entitled to representation by a legal practitioner. So that's sections 161 of the LRA. The Concord found that the issue of representation did not arise, and the issue of NUMSA's legal standing was governed by section 200 of the LRA. Well, now in assessing whether indeed NUMSA had legal standing in respect of these employees who are employed in an animal feeds industry, the court considered section 995 of the LRA. So that's section 95 of the LRA, which deals with the requirement for the registration of the trade union, including the requirements to prescribe qualification for and admission to membership. Now, the Constitutional Court held that the consequence of registering or of a trade union is that, like any normal business, it would acquire legal personality, and it is now bound to in the scope of its constitution. Any act which is outside of the constitution will be null and void because the union would not have the power to do that. It can only do that which it is permitted to do by its constitution. And now this extends the membership that it can obtain. So at this point, the Constitutional Court rejected the argument that NUMSA could act on behalf of these employees, and that such was advancing access to justice and redress for the employees. The court reiterated that section 95, and when one considers the constitution that a trade enters or concludes, then that's basically the parameters within which that particular trade union is to act. It has no power to meet and conclude membership agreements with workers in other industries or industries that fall outside its registered scope. And further, the Constitutional Court held that to distinguish between a trade union's representation of employees when enforcing national rights and representation in an unfair dismissal dispute was illogical and at odds with the very same principle that a trade union has power to act beyond the confines of its constitution. Now, the Constitutional Court also considered the Labor Appeal Court's approach in interpreting the constitution of a trade union as one of benevolence and promoting convenience and rights, wherein you recall that the LAC relied on its prior decision. So basically, in this regard, the Constitutional Court re-emphasized that you have a constitution, you are bound by that constitution. It does not take away the employee's right to join a trade union. It's just that when your trade unions, the constitution of the trade union says we only operate in industry, then there are other trade unions that operate within a particular industry. And that's exactly what the Concord said, that members needed to find a trade union that permitted them to be represented within their particular industry. And they would achieve the same effect of having access to the court and representation. It just didn't have to be NUMSA, which is limited by its own constitution. And in this regard, the Concord did find that those dismissed employees were indeed precluded from becoming members of NUMSA, accordingly, NUMSA had no legal standing in the labor court proceedings involving the employees. Now, the key takeout from this is that there's a confirmation now for the second time by the Crown Court to say that a treaty that accepts members who fall outside of its registered scope would be acting beyond its powers, and such conduct would be not. And it is important that we understand that while the LUFL concerned itself with organizational rights, this decision now extends that to include representation in any proceedings from including the labor court itself. Now, what I found interesting is that there are instances where NUMSA is still operational in an industry that is unrelated to it. Thus, it's still in British Constitution. Now, maybe to just pick your thoughts as to what would happen then when operational in those industries. Let's say, for an example, not that it's actually happening, it's now in the food and beverage sector, it's operational with members there. I think that's a topic for another thought leadership. Thank you so much, Helen.
Thanks, Amanda. Yeah, definitely lots of food for thought. And just one quick question from Daryl, which is, would this judgment also affect representation in the CCMA? And I think if you look at the CCMA rules, I think Rule 25, I think it is quite specific that if it's an employee is a member of that trade union. So I think that the logical playing this judgment forward is that you would certainly have an argument that the judgment would impact on representation. Thank you, Soraya, over to you.
Thank you so much, Helen, and good morning, everyone. So I'll be discussing the case of CCMA and others. And in summary, in this Labour Appeal Court case, Woolworths, the appellant, appealed the decision against the Labour Court in which Woolworths' review application was dismissed, and thus confirming the arbitration award issued by the CCMA. The Commissioner of the CCMA determined that the two medical certificates submitted by the employee, Ms. Maseko, were valid and regular. And as a result of that finding, the Commissioner found that her dismissal was substantively unfair. So some brief background to the matter. Ms. Maseko was an employee of Woolworths holding the position of a store specialist at the eMalahleni branch. On the 26th of June, 2018, Ms. Maseko submitted a medical certificate issued by a Dr. Frempong. Woolworths had previously received an email warning them about special medical certificates issued by Dr. Frempong. So the issuing of Ms. Maseko's medical certificate prompted Woolworths to review her employee file, and they discovered that another medical certificate from the same doctor had been issued in March 2016. However, when Ms. Maseko was questioned about these medical certificates, she said that those medical certificates were not from the same doctor and that the March 2016 note was issued by a Dr. Zanele. Woolworths then conducted its own investigation and concluded that the medical certificate submitted by Ms. Maseko was irregular. It appeared to Woolworths that Dr. Frempong was selling medical certificates. Further, the investigation revealed that Dr. Zanele was not a medical practitioner, but a nursing assistant to Dr. Frempong. Ms. Maseko was charged with misconduct for breaching company policies and procedures. She was found guilty and ultimately dismissed. So Ms. Maseko referred an unfair dismissal dispute to the CCMA. And during the arbitration proceedings, Woolworths called two witnesses who testified to the investigation into the sick notes and Dr. Frempong. The two witnesses had visited Dr. Frempong's consultation rooms where they observed people speaking with ladies at the front desk who appeared to be negotiating with what they concluded was the buying of medical certificates. People would go into Dr. Frempong's consultation rooms and walk out in minutes with a medical certificate. Based on what they observed, they concluded that Dr. Frimpong might not be a real doctor, and they suspect he was selling fake medical certificates. During the arbitration proceedings, Dr. Frimpong testified on behalf of Ms. Maseko. He testified that he qualified as a doctor, had worked in Saudi Arabia, and that he had 2 offices in Imalahleni. In one office, he employed a lady by the name of Zanele, who was his assistant and who had worked with him for more than 10 years. She had gotten to know about the management and treatment of patients, and she would see a patient when it was urgent, and when Dr. Frimpong was not available, she would refer the patient to the hospital. The commissioner reasoned that there was no evidence that Ms. Maseko was not sick on the days for which she submitted the medical certificates. Further, the commissioner concluded that based on the documentary evidence provided by Dr. Frimpong, he had the qualifications, experience, and was registered with the relevant authorities. And as such, the medical certificates were valid and complied with Woolworths' policies and procedures. Woolworths then took the matter on review to the Labour Court, which was subsequently dismissed on the basis that it had merit. Following on from this, Woolworths then took the decision of the Labour Court on appeal. Before the Labour Appeal Court, Woolworths submitted that the evidence, albeit largely hearsay, indicated that there were untoward happenings at Dr. Frimpong's in respect of the issuing and buying of sick notes. And as a result, Ms. Maseko was not sick on the 26th of June. It is important to note that the basis on which Ms. Maseko was alleged to have submitted an irregular medical certificate on June 2018 was not in relation to Woolworths' witnesses having given evidence that Ms. Maseko obtained an irregular medical certificate and submitting it to validate her absence from work. It was not in relation to having tampered with a valid medical certificate. It was also not the case of Ms. Maseko having somehow misled the doctor to convince him that she was sick. None of these possible scenarios arose from the evidence. So the Labour Appeal Court found no merit in submissions. It found the idea troubling that an employee who obtained a medical certificate from a medical practitioner could be subject to disciplinary proceedings on the basis of an employer's suspicion that the manner in which the medical practitioner conducted their medical practice was. On Woolworths' approach, a disciplinary process would be followed even when an employee may genuinely be sick and completely unaware illegal activities or irregularities at their medical practitioner's practice. The Labour Appeal Court found that the real issue was whether or not Ms. Maseko saw Dr. Frimpong on the day in question and whether he booked her off sick as specified on the sick note. Once this was established, there could be nothing else required from Ms. Maseko. Woolworths' dissatisfaction Frimpong and the manner in which he ran his medical practice, as well as the hearsay evidence from their witness, was irrelevant. And as such, the Labour Appeal Court dismissed the appeal. So what are some of the key takeaways from this case? So although we know that an dishonesty in abusing sick leave goes to the heart of the employee and employer trust relationship, employers should tread carefully when they about the integrity of an employee's sick note. Employers should be forewarned that suspicion alone about a particular practitioner is not to warrant disciplinary proceedings against an employee. As the Labour Appeal Court confirmed, it's not the position of ordinary workers to interrogate whether the medical certificates they received are from a duly qualified medical practitioner. Where employers have about certain medical practitioners, employees can and should be warned about using these medical practitioners through proper notice. Such notice to employees may only be given once the employer has established the suspicions around the medical practitioner's conduct, necessarily involve investigation by regulatory bodies like the Health Professions Council of South Africa. Thank you, Helen.
Thanks very much, Ryan. Just to quickly address Joe's question in the Q&A, in terms of what is the threshold for large-scale retrenchment. So it only applies to employers who employ more than 50 people, and then it's a sliding scale depending on how big your workforce is. So, for example, it's 10 employees if you employ up to 200 employees, and then it carries on. And you also take it with the number of employees you're contemplating retrenching, together with the number of employees you've actually retrenched, and we interpret that as not including voluntary retrenchments in the preceding 12 months. Joe, I hope that answers your question. We're going to now a bit of a change of speed in terms of what we're going to be looking at. The next two cases are going to be looking at unfair discrimination. Talita, who's one of our the experts in South Africa on this topic, so it's very well placed to take us to the first case dealing with unfair discrimination in the realm of recruitment and with reference to an employer's employment equity plans. And then Komotso is also very well placed. Well, no, actually, I shouldn't say it's very well placed to take us to this next case because it deals with the use of marijuana in the workplace. But he will be taking us through an unfair discrimination case which looks at a company's zero tolerance approach to testing positive for marijuana. Talita, over to you.
Thanks, Helen. Yeah, this case is solidarity on behalf of Mr. Erasmus, and it was against Eskom. Mr. Erasmus was employed long ago, 1988, nearly 35 years ago. He was employed as a project manager in 2004. And then I just needed to share this role title with you. He was the Senior Advisor Outage Coordinator from the 1st of January 2017. And that just sounds like switching on and off during load shedding, but I'm sure that's not what he actually did. Then a role was created at the grade of M16. Remember, he was at M15. And that was for manager site outage execution at Peking Power Station for the group technology division. And his manager, Mr. van Staden, thought that he is very well placed for this role, and he applied for this role. On the form GA13, that is an internal form that needs to be completed in the event of a recruitment decision, Mr. van Staden indicated that a white male can be appointed to this role, but Ms. Kumalu, who is the employment equity assigned manager, changed that, and she said females of all races can be considered and African males. The employment equity plan itself is drafted in fairly broad and flexible terms, and the advertisement was similarly drafted in flexible terms. It said Eskom is committed to equality, employment equity, and diversity in accordance with the employment equity plan of Eskom and its employment equity goals and targets. Preference may be given, but not limited, to candidates from underrepresented designated groups. So a number of applicants applied, including Mr. Erasmus, and candidates were shortlisted. Mr. Erasmus was shortlisted, and that was actually because on the form that he had to fill in electronically, he indicated he's African. The evidence showed that had he shown or ticked the box white male on that form, he would not have been shortlisted because of this requirement that only African males or females from all races would be considered. His appointment was motivated for, but it was determined that he would not be appointed because he's a white male. And that then prompted this application to the Labour Court. The court considered this, and it said that it is not just the court's obligation to look at whether an affirmative action plan complies with the requirements of the Employment Equity Act, but also the court's function to look at how affirmative action is being applied by the employer concerned. In this regard, the court referred back to the Barnard decision that you will all be very familiar with, a 2014 decision in which Acting Chief Justice Moseneke, as he was then, said it looked first at the constitutional right to equality. So the restitutionary measure, the affirmative action measure, must target a particular class of people. It must be designed to protect or advance those classes, and it must promote the achievement of equality. When you are taking affirmative action measures in accordance with the Employment Equity Act, that does not amount to unfair race or gender discrimination. But then the court said it does not oust the court's power to interrogate whether the measure is a legitimate restitution measure within the scope of the Constitution and then also the Employment Equity Act. So the next question that must be asked is whether the manner in which a properly adopted affirmative action measure is applied, whether that can be challenged. And the court in this case said definitely yes. It isn't enough to just say, I'm taking affirmative action measures, here's my plan, it's all beautifully drafted. But actually, the manner in which you apply it is to exclude people and impose an absolute barrier to the promotion or appointment of people who are not from underrepresented groups. So the court said, yes, we have the right to also look at the manner in which affirmative action is applied. The court said designated employers must ensure that people who are suitably qualified from designated groups are equally represented in all the occupational levels of the employer. This employment equity plan must be devised and approved. That is an internal process at the employer. The employer needs to do this rationally. It must make sense, and it must do so fairly and proportionately in relation to the rights and interests of all the different employees in the workplace that might be affected. And it must do so procedurally in accordance with what is set out in the Employment Equity Act, which means it must consult with its employees on the plan. The Act sets itself against this insinuation that affirmative action measures are a refuge for the mediocre, and that is why it refers to suitably qualified people. The aim of the Act is equitable representation, equitable across all races and genders. In relation to quotas and absolute barriers, the court said Section 15.4 sets the tone for the flexibility and inclusiveness required to advance employment equity. It makes it quite clear that a designated employer may not adopt an employment equity policy or practice that would establish an absolute barrier to the future or continued employment or promotion of people who are not from designated groups. The court said in this case there was no dispute that Mr. Erasmus was denied because he was white. In fact, it was wrong that he was shortlisted because he had clicked African on the form. And the example from Eskom that no, if we didn't get anyone from the groups that we were looking for, there would have been a second round of applications. That didn't cure this defect in the process. The fact that he was excluded from being shortlisted was a blunt, inflexible measure that was practiced at the shortlisting stage of the recruitment phase, and that was regarded as an absolute barrier to this specific excluded category, white males. So the court then held that because of the way in which the shortlisting was approached, that was an absolute barrier. It amounted to unfair discrimination on the basis of race, and it ordered Eskom to pay Mr. Erasmus an amount equal to 18 months remuneration at the time that he applied for the post in question. I think what is important is that we must look carefully at our plans, employment equity plans. The plans need to take into account the context in which the various designated employers find themselves, the pool from which they are finding candidates for employment. But more than that, we must make sure that when those plans are applied, they are applied fairly, rationally, and proportionately. And absolute barriers must be a no-no in your organization. Thanks, Helen.
Thanks, Talita, and over to Komotso.
Thanks, Helen, and morning, everyone. Helen just kicked me at the table that we need to manage time, so I'll go very quickly. So the case I'm dealing with is Enova versus Barloworld. This case was heard in November 2023, and the judgment was delivered, I think, April 2024, and it's a labor appeal court decision. So I'm going to spend a bit of time on the background and the context, and then just summarize the LAC findings. So as Helen said, it's also an unfair discrimination case, and this relates to the use of marijuana, or dagga for some of us. And in short, the appellant tested non-negative for cannabis, and this was on the 29th of January 2020. Interesting here is that the concord, as we may know, in the case of Prince, Minister of Justice and Constitutional Development and others versus Prince, in 2018, gave a decision decriminalizing the use of marijuana in private. So you may cultivate and use marijuana in private, and this is what the case this case is centered on, in essence. So just in terms of factual background, the appellant in this matter, the employee, is an employee of Barloworld, and she was diagnosed with anxiety, severe anxiety, back in 2012, and medication was prescribed for her use, and she complained of severe side effects from this medication. However, she then, in evidence, she said that when dagga was decriminalized, she started using it, and she found that in using dagga, the side effects had subsided, and therefore that is what she stuck with instead of using the prescribed medication. So one fateful December, the employee went on holiday leave, when she came back in order to gain access, the company had a policy to do routine testing for employees to gain access to the biometrics and so on. And in this instance, the employee was one of those people who was tested. When tested, it was found that she tested non-negative for marijuana, and as we said, and the policy is that you get sent home for a few days, and then you come back for regular testing, and you're not allowed back into the premises until you test negative. However, the employee continued to test non-negative, and as a result, around September, end of September, 25 September, she was then charged with testing positive or non-negative for the use of marijuana, which is prohibited in terms of the internal policy. And later on, she was dismissed. Interesting in relation to the disciplinary hearing, and this is the stance that she adopted as well at the arbitration, is that she indicated she's using marijuana, she pleaded guilty, and that she's not going to stop because she's using it for her health purposes, recreational purposes. And at the time of her testing, she was not impaired, it was established, in the performance of any of her duties, or suspected of being intoxicated. So there wasn't anything about her physical appearance that said she was intoxicated or that she could not do her job. And important as well, she was office-based. She did not operate dangerous machines or drove for the company. At the Labour Court, there were 4 questions which the court grappled with. The first was whether there was differentiation between the appellant and other employees regarding the policy. The second was whether there was a causal link between her positive test and dismissal, that's constituting discrimination. The third was whether the policies were unfair and discriminatory. And the last one was whether the respondent impaired the appellant's dignity by adopting what she called an insulting, degrading, and humiliating policy. The court found that the policy was consistently applied to all employees who tested, and that there was no evidence that other employees who tested positive were treated differently. It was concluded that the policy on this point, on the first point of the first question, that the policy creates a rule that applies to all employees consistently, and further that the appellant failed to stop the use of cannabis despite knowing that she will test non-negative. And there was a direct causal connection the court accepted. And this point was also accepted by the LAC, and they did not deal with it, that there was a causal link, and that the dismissal was found to be, her use of cannabis was found to be the reason for her dismissal and her refusal to stop. On the third question, the court found that the appellant had to show that the policy differentiates between employees, but her submissions in this regard were rejected. As I said earlier, the court found that the policy was applied consistently. And then on the fourth question, the court found that this case evolved around misconduct and therefore not discrimination. And they were quick on that point to dismiss it. And the reason given here was that the appellant was aware of the policy and that she intentionally breached that policy. So therefore, the court found there was willful violation of the policy. In the appeal court, the same 4 issues were considered by the appeal court. However, as I said, the court accepted that there is no point looking at the causal link because that was accepted by the respondent. I think I just want to pause here and refer to Section 6.1 because this is the base upon which the court, the Labour Appeal Court made its finding later in the judgment. And this you find in paragraph 22 of the judgment. Section 6.1 says, no person may unfairly discriminate directly or indirectly against an employee in any employment policy or practice on one or more grounds, including race, gender, sex, pregnancy, marital status, family responsibility, ethnic or social origin, color, sexual orientation, age, disability, religion, HIV status, conscience, belief, political opinion, culture, language, birth, or on any other arbitrary ground. And the court then stated that in an instance when employee relies on a listed ground, it is then for the employer to prove, the onus is on the employer to prove that there was no discrimination. However, if the case is based on humanitarian grounds and not on the listed grounds, then the onus changes and it goes to the employee. In this instance, the court established that the appellant's case was based on the listed grounds. In short, the Labour Appeal Court agreed with the Labour Court that there was no discrimination on any of the listed grounds, that dismissal was not as a result of religious or spiritual views, as the employee asserted, and that she herself admitted that she smoked dagga for recreational purposes, and therefore there was no discrimination on religious ground. In paragraph 31 of the judgment, the court summarizes what the authority is and what the position is when you consider how to interpret and determine discrimination on humanitarian grounds. And it says that this is in paragraph 31, as I said, to summarize, where reliance is placed on an arbitrary ground, a complaint in an unfair discrimination claim is required to establish that they have been the object of unequal treatment based on attributes and characteristics they either possesses or with which they are associated and which have the potential to sully or diminish their intrinsic humanity and that of others and their situation. It is the impact on the complainant which is decisive. And what the court found in this instance was that the Prince case, in essence, gave the right for employees to use cannabis in their private residences. And that a policy like this of the respondent, which gave a blanket prohibition for work entry if you are intoxicated or under the influence, actually violated the right to privacy. And it was therefore found that the policy had to change and it had to look and take into account the private rights of employees. And I think what I found curious in relation to the finding and particularly the analysis of Mlambo, J.A., was he did not go as far as how far do you go in terms of taking into account when you establish company policies to take account of people's private rights. I mean, what we can't dispute is that the case of Prince does give people the right to smoke dagga, but also as an employer, if someone comes and says, I drank alcohol, whatever drug they use at their private home, how do you then regulate in your workplace to make sure that you protect the employees? I think what was decisive here, although this is not something the courts emphasize on, is that the employee did not work in a dangerous environment, that she was office bound, and also that although there was no evidence which was presented both at the disciplinary hearing and also at trial, that the use of dagga helped her ease her anxiety, or that it was medicine. The court seems to have accepted that must be some of the reasons that are taken into account, and therefore the company is going to have to make sure that the policy that it puts in place accommodates people's private rights. And that is the essence really of the court's finding. As I said, it's very curious for me how far you go. And I think it is therefore important when we put policies in place that we consider the impact of cases like Prince in this instance and other cases that somehow gives people rights in their private life, to make sure that we don't infringe on those rights. But how far that goes, I think, will depend on the context and the circumstances. In this case, I just think the court could have done a bit more to explain how is this different, but also how far does this go in making sure that the employer is still able to ensure that there is no discrimination in the workplace. Because the moment you have a policy that applies to a certain group of people and to the exclusion of others, you also face challenges, you face a problem. And you are then going to have to justify why that is the case. And I think an employee who comes without any evidence whatsoever and says, I use DACA because it eases my anxiety, it was dangerous in my mind for the court just to accept that as a reason to make the policy to be, I think the finding was that the policy was unfair and that it discriminated against the employee. And 24 months compensation was granted to the employee. There was no reinstatement, but 24 months compensation. Yeah, I think I'll end it here, Helen.
Thanks, Khumuldzo. You raised some very interesting points. I think lots of food for thought, and also goes to show that you get your judgment in the Labour Court, and you just know that in the Labour Appeal Court, there's a high chance that you're going to get a different outcome. And we see that happen a lot. Thanks so much, Khumuldzo. Our next two cases, Roz is going to take us through. And along with Khumuldzo, Roz does a lot of her own appearance work. So I know these two cases will be something that she'll have I think we'll probably have quite strong views on, because the first one deals with retrospective reinstatement and the question of of back pay, which is something that we have seen coming up periodically in the cases. And the next one is a complete pivot that is dealing with restraints of trade. And we know that's something that it goes before our Labour Court and our High Court frequently, that they deal with lots of restraints of trades matters. And that is something, again, that I'm sure for lots of people on the call have been involved at some point. So Roz, over to you to take us through the next two cases.
Good morning, everyone. Thanks, Helen. So the first case, as Helen said, really deals with the issue of retrospective reinstatement. It's Oudtshoorn Local Municipality versus Titia and others. What happened in this case, and unfortunately, we don't have any of the nice juicy facts leading to the dismissal, so I can't tell you a nice story to start with. It just goes really into the legal principles. So what happens in this case is we have an employee, he is dismissed. He challenges his dismissal in I think it was the CCMA, no, it would have been probably Bargaining Council. Challenges the dismissal in the Bargaining Council, and ultimately the arbitrator finds that his dismissal is substantively unfair. Now, as I think we all know, that the primary remedy for a substantively unfair dismissal is either reinstatement or re-employment, unless the employee doesn't want to be reinstated, or it would be intolerable to order some form of reinstatement or re-employment. So the arbitrator had considered this, and the employee had said he wanted to be reinstated. Now, ultimately, the arbitrator then agreed and said, look, it's a substantively unfair dismissal. He needs to be reinstated, and I am awarding him retrospective reinstatement. But the arbitrator then went on to limit the back pay payable to the employee to a period of 6 months. The arbitrator's reasoning for limiting this period of back pay is that the employee had been on paid suspension for a significantly long period of time, and the arbitrator felt that that was a justification for limiting back pay for the dismissal period. The employee sought to review the arbitration award on the basis that of the limitation of this back pay. The municipality, on the other hand, brought a cross review to also review the award. But ultimately, the municipality withdrew the cross review on the basis that a decision had been taken to reinstate the employee, and therefore the cross review was moot. So the sole issue before the court was to determine whether or not it was sufficient and fair to limit the issue of back pay. The what the court looked at in determining this issue was what constitutes reinstatement and what constitutes reemployment. And the court said that in considering, the court in considering the review application had regard to the Constitutional Court decision in Equity Aviation, which found that reinstatement, or the ordinary meaning of reinstatement, is to put the employee back into the job or the position he or she had occupied before his dismissal on the same terms and conditions. And as put otherwise, he said, essentially, the court needs to be put into the position he would have been at the time of his dismissal. The court confirmed that the court, however, confirmed that with the issue of retrospectivity, you can either award reinstatement to date of dismissal, which would be the entire period, or you can award reinstatement to a different period. So you can shorten that period. What you obviously can't do is, what the court can't do is lengthen the period. So the court did accept that reinstatement may be ordered from a date later than the date of dismissal, and therefore that back pay can be limited. On the issue of reemployment, the court said this, on the other hand, implies that the previous employment relationship is terminated and a new employment relationship comes into being by virtue of the award, and that the issue of compensation as a remedy will only apply in a substantively unfair dismissal where there is where the employee doesn't want to be reemployed or reinstated, or where the reinstatement or reemployment would be intolerable. In circumstances where it would be intolerable, it is very important to remember that it would be for the employer to lead evidence to show why retrospective reinstatement would be intolerable, or reemployment, or just a limited period of reinstatement. What the court then said, though, or made very clear, is that the issue of compensation is different to back pay. So compensation is a monetary amount. It's limited to 12 months, as we all know, for an ordinary dismissal, and 24 months for an automatically unfair dismissal. But it is not the same as back pay, and back pay is not compensation. The court then considered the award of the arbitrator. And as I said, what the arbitrator said is, I am reinstating the employee retrospectively to date of dismissal. And the court said that the arbitrator failed to understand that retrospective reinstatement to date of dismissal means that the employee is entitled to be back paid for the complete period of unemployment. The court also found that determining that the cap on the amount of back pay to 6 months based on the fact that this employee had been on paid suspension for a period wasn't a sound reason for limiting back pay. But ultimately, the court said that the arbitrator's finding was a material error of law that rendered the award reviewable. The award was then substituted with an order that the municipality pay full back pay for the period of unemployment. So the lesson from this is, very importantly, firstly, we all know that reinstatement or reemployment is the primary remedy. If the employer believes that there is a risk of reinstatement, or even if it has a solid case, it is always good to lead evidence to say, well, in the event that the dismissal is found to be substantively unfair, these are specific reasons why a full award of back pay should not be made if the employee is reinstated retrospectively. And then the argument, or the submissions to the arbitrator must clearly be that retrospective reinstatement to date of dismissal is not appropriate, and therefore reinstatement must be to a different date. So whether, if this arbitrator had awarded reinstatement to 6 months prior to the arbitration, then that 6-month back pay would have been in order. So please bear that in mind. I know a lot of you do your own internal arbitrations, your own court proceedings. It is absolutely essential that you bear this in mind, especially if you are faced with a matter that's been going on for a significant period of time. And one of the issues, or one of the areas where a court will consider limiting reinstatement, is if the delays are occasioned by the employee. So if the employee doesn't take appropriate steps to pursue the claim diligently, alternatively, the employee keeps postponing the arbitration. So please bear that in mind. It is quite an important issue for consideration. Okay, the next case is MPU Communications versus Griffiths and others. As Helen said, this is a restraint of trade case. And I think there were 5 respondents in this matter. At the outset, it's important to know that in respect of 3 of the 5 respondents, the dispute was settled. The 3rd respondent did not oppose the relief being sought by the employer, and therefore the relief was granted against the 3rd respondent. So this case really turns on the defense raised by the 2nd respondent. I'm just going to refer to the applicant as the employer and the 2nd respondent as the employee, as if they were the only parties, just for ease of reference. So what happened in this case is MPU Communications, the employer, had restraints of trade in terms of its contracts of employment with various employees. The employer in this case was employed as the national channel manager. So by virtue of the title, it would appear that his involvement or his work entailed work with customers and clients nationally. It wasn't limited to the branch where he was, which was in Pretoria. The restraint of trade, however, provided for that he would be restrained from working for a competitor within a 100-kilometer radius of the branch at which he was employed. The employee was paid an additional 1,000 Rand a month for a restraint payment for the duration of his employment. The applicant, the employer, sought to enforce the restraint and alleged that the employee had, following his dismissal, and in fact during, I think, his notice period, had breached the terms of his restraint. Now, in this matter, what had happened is the employer had undergone a retrenchment exercise, and it was downsizing. The employee and various other employees were retrenched. And although they did not work during their notice period, what the employee in this case had been told was that any sales that came through during the period of his notice, he would receive commission on those sales. So he had an interest in ensuring that sales continued to be finalized during his notice period. During the notice period, or shortly after the notice period, the employer approached the employee and requested that he sign various undertakings in terms of that aligned largely with the restraint of trade, but went further than the restraint. The employee just said no, he wasn't willing to sign further undertakings. As a result of that, the employer approached the court to interdict him from breaching his restraint and essentially to enforce the restraint. And the employer claimed that his refusal to sign the restraints was really, or the undertakings, was the trigger event. Now, it is trite in South African law that restraints of trade are generally found to be enforceable as long as they are reasonable and that they are necessary to protect the employer's proprietary interests. So essentially what the court looks at is there a proprietary interest worthy of protection? If there isn't, then a restraint of trade will be found to be unreasonable. And then, is the restraint reasonable in relation to geographical location and the duration? Now, in this case, I think the restraint of trade was for a 12-month period, but that was never, there was never any contentious issue about whether that was reasonable or not. So the court doesn't deal with that. What is important then to bear in mind when dealing with restraints of trade is the onus is on the employer to prove A, that there is a restraint of trade, and B, that the employee has breached the restraint of trade. And then for that onus will then shift to the employee to prove that the restraint of trade is unreasonable. However, as employers who are seeking to enforce a restraint, when you are putting together your case, it is important to go a bit further and show that there is a proprietary interest worthy of protection, and then to establish why in broad in broad terms why you say the restraint is reasonable. So very important just to bear that in mind. It's not sufficient just to go on a very basic, well, we've got a restraint and you must enforce it. You've got to show that there's a restraint. You've got to show that there is a breach of the restraint, and at the very least show that there is a proprietary interest worthy of protection, or in other words, show that there is a risk to the business or harm to the business. Now, in bringing an application to enforce this restraint of trade, the applicant was also required to show they were seeking final relief. So they were required to show that there was a real right. Again, that goes to your proprietary interest, and that there was a reasonable apprehension of irreparable harm. So there was a reasonable apprehension that the employee had or would breach the restraint of trade, and that they would suffer harm as a result of the breach. In this matter, the employee's application fell short in the following respects. Firstly, the employer failed to establish that the employee had in fact breached the restraint. So it wasn't in dispute that there was a restraint of trade. It wasn't in dispute what the terms of the restraint was, but the employer failed to establish that the employee had breached the restraint of trade, and effectively sought to shift that onus onto the employee to establish that he hadn't breached it, which the court said you can't do. The employer also relied on personal emails that the employee sent from his personal email account. And part of the evidence before the court was taken from emails that he sent from his personal email to the fifth respondent, which was a competitor of the employer. Now, in this regard, the employer fails to set out any explanation as to how they came by these emails, whether the emails were lawfully obtained, and whether or not they constituted lawful evidence before the court. The employee, on the other hand, said that in order to have obtained these emails, the employer must have hacked his email account, and that was an unlawful infringement of his right to privacy and of the Electronic Communications and Transactions Act. The other area where the employer failed, or where the application was wanting, was that the employer sought to increase the scope of the restraint. So the relief being sought by the employer was that the employee be restrained from working for a competitor within a 100-kilometer radius of any of its branches nationally. And the court said you can't do that. Now, in court, when the matter was being argued, the employer acknowledged this and sought to limit the relief being sought. And the employee said, no, you can't do that. You can't seek to limit the relief in circumstances where you have not amended the papers. So that's a very technical issue, but it is important to bear in mind that you shouldn't be trying to increase the scope. Insofar as the emails to the competitor are concerned, the employee's explanation was this: a prospective client had approached him while he was the national the national manager, and was seeking to get services or telecom services from the employer. Because he was still in his notice and he knew he could still get commission, he was trying to close that deal, but the client or the prospective client needed financing. In order to obtain that financing, the prospective client had requested that the employer finance the deal. That was not possible, and for this reason, the employee had contacted the competitor to give financing so that this prospective client could purchase the product from the employer. That was his explanation for then forwarding the information to the competitor. The court accepted this explanation and said that the employer's complete failure to provide any evidence that the employee was working for or intended taking up employment with the competitor was fatal to its case, because the court said that they had to establish that the employee had breached or was in the process of or intended to breach the restraint. And in the absence of that, the application should fail. The court declined to consider whether or not there was an unlawful interception of the employee's emails on the basis that those emails didn't take the matter further, and they did not establish that there was any breach of the restraint by the employee. So essentially, the court found that the application sought to be dismissed in respect of the second applicant, the second respondent, apologies, and that there was no basis on which to enforce the restraint of trade because there was no evidence of a breach. So there, in a nutshell, bear this in mind. We have questions on this all the time with employers who think that their employees might be breaching a restraint or their ex-employees might be breaching the restraint. It is absolutely crucial. If you go to court to enforce a restraint, you must show that there has been a breach of the restraint. It's evident on a balance of probabilities. So it's the normal civil test, but please bear that in mind. And before you try to run off to court for this, you need to ensure that you have that evidence. Otherwise, you are not going to succeed in enforcing a restraint. Thank you so much.
Thanks so much, Rose. Before we finish up with our last cases on review and hand over to Sarai, there was just one last question in the Q&A from Joe, and that, is it advisable for employees to declare the use of marijuana for recreational or health reasons to enable the company to determine whether it's safe to keep them in jobs deemed to be dangerous? We don't have time to unpack that. I think it would take a longer conversation, but I do think there could be quite a lot of merit if someone is using it medically and it could impact on the job, that actually the onus is on them to come to upfront that. Perhaps be I'd be more circumspect where it comes to recreational use. But I think, just to Komotso's point, where you are in an environment where you are working with heavy machinery or it's otherwise dangerous, I think I'd also be quite loath to do anything in your policies which undercuts a zero tolerance approach. So I think you'd have to be very careful. I think you do need to relook at policies, but I think you need to be very careful how you do that so you don't put too much of the onus on you as the employer. But I'll just leave it at that. Sarai, thank you very much. This one should be quite quick, so hopefully we'll finish on time. Yeah, but over to you, Sarai.
Thanks so much, Helen. So the next case I'll be discussing is the Jewellery Council of South Africa versus Maharaj. So in this case, the Jewellery Council, the company, sought to review the arbitration award issued by the CCMA, which held that an erstwhile employee's dismissal by the company was substantively unfair. The Labour Court held in summary that there was no merit to the company's main grounds for review. It did find that in calculating the compensation awarded, the arbitrator committed an error of law in that he failed to take into account the employee's at the time of her dismissal. as outlined in Section 194 of the Labour Relations Act. So some backgrounds to the case. Prior to her dismissal, the employee, Ms. Indira Maharaj, had been in the employ of the company for over 13 years. She was employed as an accountant. On the 29th of April, 2021, the company issued a letter to the employee announcing that short-time work will be imposed for as an accountant from the 3rd of May. This entailed a reduction in the number of days she worked from 5 to 3, and her salary would be reduced by 40%. Notwithstanding the change in circumstances, the CEO sent the employee various emails inquiring about work-related matters on days meant to work, including a Sunday. On the following Monday, upon arriving at work, the employee entered the CEO's office. An altercation ensued. The employee was alleged to have told the CEO that the CEO was, quote unquote, raping the company on the basis that the CEO did not take a salary reduction when the employee did, that the CEO was too weak to make decisions on her own and the employee of her, that the CEO should be bringing business to the company instead of sitting behind her desk and is just a pretty face who sits and drinks wine when the Lex conference, and that the CEO was the reason the company lost money on a marketing campaign, approximately 2.5 million rand, causing suffering to the staff. A day later, the company charged the employee with gross misconduct in the form of gross disrespect, issuing threats to the CEO. A week later, and following a disciplinary hearing, the company dismissed the employee. Aggrieved by dismissal, the employee referred an unfair dismissal dispute to the CCMA. The arbitrator found a dismissal to be substantively unfair and ordered the company employee 8 months compensation calculated at the rate of her remuneration she received prior to the salary reduction. The company disagreed with the outcome and brought an application to review and set aside the award. The challenge against the award was mounted on alleged irregularities, evidenced by the failure on the part of the commissioner to apply his mind. Further, the company contended that the commissioner exceeded his powers, 8 months compensation at the remuneration rate prior to the employee's reduced rate. So the findings of the Labour Court, that the grounds for review lacked merit in relation to the reasons for the dismissal, the judge confirmed that the test for review is whether the decision is one the decision maker could reach. In determining the matter, the arbitrator considered the context that led to the altercation and statements made by the employee were true. Based on evidence at the arbitrator, the court accepted the following as facts. The company experiencing financial challenges. The employee was the only one affected by short-term work and received a 40% salary reduction. The employee, as an accountant, was critical to the company and was demanding and required her to work more than 3 times a week. The CEO did cut, and the company did waste 2.5 million rand on a marketing campaign that had no benefit to it. The CEO did the whole day when they attended a conference. Therefore, what was said by the employee during the altercation was largely factual, and the CEO was guilty insofar as the altercation was concerned. And as such, the arbitrator's decision was not unreasonable, and the Labour Court dismissed the view. On the compensation to be awarded, the court had regard to the fact that Section 194(1) of the LRA provides compensation to be awarded to an employee whose dismissal is found to be substantively unfair may not exceed the equivalent compensation and must be calculated at the remuneration rate of the employee at the time of dismissal. In awarding 8 months compensation at the rate before her salary reduction, the arbitrator committed an error of law. The Labour Court accordingly set aside aspect of the award and substituted it for compensation at the remuneration earned at the time of the employee's dismissal, the reduced. So some key takeaways of the case. The judgment highlights the importance of arbitrators abiding by the limits of compensation provided for in Section 194. And it is significant in this case that the employee did not challenge the unilateral decision of the company to reduce her salary. Had she done so, or had she instituted a cross review to claim the maximum compensation at the reduced salary rate, the outcome may have been different for her. Thanks so much, Helen.
Thanks, Joanna. Yes, another lesson about being careful on taking reviews to the Labour Court as if they're appeals. Thank you all. That brings us to an end of this ELU. Next time we see you, it will hopefully be a lot warmer and spring. We hope you all keep warm and safe, especially if you're in the Cape. The weather looks a bit wild. But thank you so much for all of your time and keep well, everyone. Cheers.